Good evening, ladies and gentlemen. Right, the employment law and part one. Right, so we have to start today from the slide number 38. Do you hear me?
Yes, sir.
Yes, sir.
Right. So can you just refer, right, the note that you have taken? What is the last, I mean, the what? Could you tell me the last note? I mean, last para or last sentence of the note? In the previous session? Do you have the note with you? Can somebody tell me? We discussed weekly holidays, right? Under Open Office Employees Act, right? Hello, can somebody tell me? Do you hear me? First of all, nobody is responding. No. Hello. Can somebody tell me, right, what is the last note that you have taken? Was nobody attending in the previous session? I don't understand. Right. So we are supposed to start from 38, slide number 38. Okay. Payment for work on holidays. No. Payment for work on holidays. Take note. Our topic was, remember, introduction to employment law and employment law part one. We have, I think we would be able to finish today this presentation. So next subtopic is, I don't know whether you have taken note or not, right? But I have given, right? So this is not, there is, right? I mean, this is not a joke, huh? Payment for work on holidays. Payment for work on holidays. Right. Right. Under Open Office Employees Act, under Open Office Employees Act, under Open Office Employees Act, if you work, a worker, if a worker, under Open Office Employees Act, if a worker works on weekly holiday for 8 hours for 8 hours, for 8 hours, within bracket, normal working day, within bracket, normal working day, close the bracket. He or she entitles for 1.5 days salary, 1.5 days salary, one and half a day's salary, and a paid holiday, within next 6 days. Paid holiday within next 6 days. Okay. Right. Right. Full stop. And then as 1 day salary, as weekly holiday is paid holiday, paid holiday and 1 day salary, is included in the monthly salary, half a day additional salary, must be paid, and
The sentence from is included in monthly salary.
Additional half a day salary should be paid and it attracts I mean additional salary, additional, it attracts EPF and ETF as well. EPF and ETF as well. What does it mean? You have to understand. Under this Open Office Employees Act, right? Monthly salary means 30-day salary. Meaning that OA days, public holidays, weekly holidays are paid holidays. If you work on your weekly holiday, you are entitled according to Act. You are entitled for 1.5 days salary. Only for normal 8 hour, right? Only for 8 hour, right? As 1 day salary already they are in your 1 month salary. 1.5 means half a day additional salary must be paid to you. And it should be added to the basic salary separately because it attracts EPF and ETF. Is it clear or not? If you do not, discuss or communicate with me, I assume that you understood everything, right? I mean, this is not a joke, right? This is not a O-level or A-level class. This is a professional class, professional lecture. You have to, right? When I raise questions, you have to answer. Is it clear or not?
So if you don't mind, can you explain the content that you explained previous again?
Okay, right. Are you working somewhere or not?
No, sir, I'm studying software engineering degree.
Okay. If you work in a shop or office, you are paid, monthly salary. I mean, for 30 days. It means you have 1.5 days weekly holiday per week, and you are entitled for full moon days as holidays, and 8 mercantile holidays. We have already discussed these things. In case if your employer asks to work on your weekly holiday, normal working day, right? Normal working day means 8-hour working day, right? Only 8 hours. 8 hours is the normal working hours, right, per day. If you work on your weekly holiday, access, your employer has to pay 1.5 times daily wage for you. 1.5 times, 1.5 times. Does it mean that, say, for example, your monthly salary is 30,000, assumes, right? Your weekly holiday is half a day on Saturday and full day on Sunday, assumes. Then your employer asks you to work on Sunday, I mean on your weekly holiday, and then access your employer supposed to pay you 1.5 times daily wage for 8 hours. 1.5 times means your employer, now you are getting monthly salary 30,000. You work on Sunday. It doesn't mean that, it means that, the day salary for 8 hours is 1,000. 3,000 divided by 30 days, right? 1,000 per day. It doesn't mean that you are getting 1,500 additionally, right? 1,500 apart from your monthly salary. Because even though you work your, the weekly holiday, even though you do not work, that day salary has already been included in your monthly salary, because under the Sopan office, you are getting monthly salary for 30 days salary. Whether you work on your weekly holiday or not, your salary is there. So if you work 1.5 means 1 day salary is already there, therefore half a day salary, I mean the 500. Additionally, you are entitled to get. Is it clear right now or not?
Yes, sir, clear. Thank
Right,
you, sir.
right, right. Okay, right. Next para. Uh, if the worker works if the worker works more than 8 hours, for extra hours, for extra hours, for extra hours, for extra hours worked, for extra hours worked. The employer has to pay 2 times of hourly wage, 2 times of hourly wage as overtime, right? Overtime payment does not attract EPF and ETF. However, right, if worker works on weekly holidays, additional payment up to 8 hours per day attracts EPF and ETF. You know why I'm saying that, in some offices and shops, right? What the employers do is, if you have to work on a weekly holiday, they calculate overtime and pay as overtime separately. But it is wrong, because they don't pay EPF and ETF for that one. If you work on weekly holiday, Poya day, and mercantile holidays, up to 8 hours any day, extra salary must be added to this basic, but separately, because it attracts EPF up to 8 hours. If you work more than 8 hours, those are overtime, right? You have to understand what do you mean by overtime. Overtime means, right, extra hours you work after 8 hours. 8 hours is normal working day, whether it is Sunday or weekly holiday or Poya day or mercantile day or normal day. Up to 8 hours is a normal working day. Okay? Do you understand? Is it clear? Okay, what to do, right? Next para, under the Wages Boards Ordinance, so far we discussed provisions under Soap and Office Employees Act. Under the Wages Boards Ordinance, weekly holiday is an unpaid holiday. Unpaid holiday. Therefore, if worker works, if a worker works on his weekly holiday, on his weekly holiday, he is entitled for additional 1.5 a day's salary. 1.5 a day's salary. It should be added to the basic, and it should be added to the basic, and it attracts EPF and ETF. Right. Then subtopic statutory holiday. Statutory holiday. There are how many statutory holidays? Sometimes it is called public holidays. How many? How many statutory holidays? How many statutory holidays? How many statutory holidays? Statutory. There are 8 statutory holidays, right? Take note, there are 8 statutory holidays. There are 8 statutory holidays. There are 8 statutory holidays. I repeatedly asked someone, what is the note that you have taken previously? According to my note, today we are supposed to start from slide number 38. So in order to make sure, right, I repeatedly ask who has attended in my previous class, right, last week. What is the note that you have taken, the last note? Kavisa, did you attend?
No, sir. Actually, there's a current issue now. So at
Okay,
that
okay,
time,
right,
there's a secret issue.
right. Who was attending? Anybody? Okay, right. Anyway, right. There are 8 statutory holidays. What are those statutory holidays? Right. There are 8 statutory holidays. Number 1. Right. Statutory holidays. Number 1. Independence Day. Independence Day. Just 1 second. Yeah, Independence Day. Number 2. Number 2. Just 1 second. Yeah, I'm trying to get his order. Right, just give me 1 minute. Right. Sorry. Number 1. Yeah. Number 1. There is no order, right? Independence Day. Tamil. Sorry. Thaipongal Day. Thaipongal Day. Thaipongal Day comes should come first. No, it comes on January or February. No, January. Thaipongal Day, and then the Independence Day. Number 3. Day prior to Sinhala and Tamil New Year. Day prior to Sinhala and Tamil New Year. Day prior to Sinhala and Tamil New Year. Number 4. Yes. Tamil and Sinhala New Year. Tamil and Sinhala New Year. And then next one, day prior to full moon, day prior to sorry, day not prior, day following Vesak full moon poya day. Sorry, day following Vesak full moon poya day. Just give me 1 minute. Just 1 second. Give me, sorry, 1 minute. Yeah, number 1, I told you Thaipongal Day. Number 1, Thaipongal Day. Number 2, Independence Day. Number 3, May Day. Number 4, right? Number 4, the Sinhala and Tamil. Day before the Sinhala and Tamil New Year, and then Sinhala and Tamil New Year. And next one, day after Vesak full moon poya day. Day after Vesak full moon poya day. And birthday of Prophet Muhammad. And number 8, Christmas Day. Number 5, Number 4 is number 4 should be Sinhala and Tamil New Year. Number 5, day after Sinhala and Tamil New Year. එකට පස්සේ දවස, day after. Okay, these are what you call mercantile or public holidays. Right. Public holidays. Or sometimes it is called statutory holidays, mercantile or statutory holidays. Right? Under Soap and Office Employees Act, all above 8 statutory holidays, are paid holidays. Right. In case if worker has to work all above 8 statutory holidays are paid holidays under the Soap and Office Employees Act, right? If worker has to work on any statutory holiday, any statutory holiday, up to 8 hours. 8 hours means the normal working day. Remember, 8 hours means normal working day. Up to 8 hours. He is entitled for 2 times of day salary. 2 times of day salary. 2 times of day salary. Day salary is calculated dividing monthly salary by a number of 30 days. Right? As 1 day salary already included. As 1 day salary already included, within bracket, irrespective of work. Irrespective of work. Irrespective of work. Close the bracket. It means that whether you work or not, right, your salary is there in the monthly salary. If you have to work, right, has to add, he is entitled for what I said. Can somebody pronounce it? I mean, tell me, I don't remember now. So can somebody repeat it? Can somebody read what you have written?
Day salary already included.
From the beginning onwards, right? I mean, tell the tell me the entire sentence.
In case if worker has to work on any statutory holiday up to
any statutory holiday, okay.
Up to 8 hours.
Up to 8 hours. Okay, up to 8 hours.
He is entitled for 2 by day salary, 2 multiplied by day salary as 1 day salary already included
Or
In bracket,
2 day salary, full stop, right? 2 day salary, full stop. Then as
1 day salary already included in the bracket irrespective of works.
included in the monthly salary, in the monthly salary, in the monthly salary. Employer has to pay 1 day additional salary. 1 day additional salary. 1 day additional salary. 1 day additional salary. Right? 1 day additional salary. And it should be included into the basic and pay EPF and ETF as well. Otherwise, instead of payment, instead of additional payment, instead of additional payment, day off can be granted. Day off can be granted. Day off can be granted with pay. With pay before the end of the year. Next para, same principle is applicable. Same principle is applicable. Same principle is applicable to the workers covered by the wages boards. Covered by the wages boards. Covered by the wages boards. However, it is important to note that it is important to note that workers covered by the wages boards do not enjoy all eight statutory holidays. It may vary from wages boards to wages boards. Wages boards to wages boards. sorry, it may vary from wages boards to wages boards. Right. Then subtopic POA day. POA day. Full moon POA day. Sorry, full moon POA day. Payment for work on holidays. We are talking about the payment for work on holidays. First, we discuss weekly holidays and statutory holidays. Now, full moon POA day. Full moon POA day. Right. Under the Sopan Office Employees Act, under the Sopan Office Employees Act, full moon POA day is a paid holiday. Paid holiday. Paid holiday. Therefore, if worker works,
So can you repeat the sentence again?
under the Open Office Employees Act, full moon POA day is a paid holiday. Paid holiday. එදා වැඩ කරත් නැතත් මාසේ පඩිය ඇතුලේ ඒ දිනේ වටුප තියෙනවා. That is what you mean. What do we mean by paid holiday? Because under this Open Office Employees Act, right? Monthly salary means 30-day salary. Okay, right. If worker works, right? If worker working in a SOPO office, working in a SOPO office, working in a SOPO office, works on a full moon POA day, within bracket up to 8 hours. That is the normal working day, 8-hour working day, close the bracket. Full moon POA day. He is entitled for half a day's additional salary. Half a day's additional salary, which attracts EPF and ETF. Which attracts EPF and ETF. If payment, next para, if payment is made on daily basis, daily basis, 1.5 days salary, 1.5 days salary must be paid. Next para. Under the, sorry, the workers, let me put in this way, right? under the Wages Boards Ordinance, under the Wages Boards Ordinance, scenario is similar as above. Scenario is similar as above. Scenario is similar as above. Okay. Is it clear? Any questions so far? Any question? Or is it clear? This has become a O-level and A-level tuition class now. It's not like a professional. Anyway, what to do? Right. Next, my next slide talks about how to calculate overtime rate. Overtime rate. Right. SOEA means SOP and OP's Employees Act. OT means, overtime. Overtime rate is calculate monthly salary divided by 240 multiplied by 1.5 times. When you divide monthly salary by 200, what do you get? When you divide monthly salary by 240, under the SOP and OP's Employees Act, why monthly salary is divided by 240? For what? Why 240? Why 240? ඇයි 240න් බෙදන්නේ මාසෙ වැටුප? Why is it?
Eight by 30, no sir. Working hours multiplied by the days of the month, no?
Overtime rate means, what do you mean by over? You're good, right? You are having some answer. Overtime rate means, what does it mean? Hourly rate, right? Overtime rate means overtime is paid, this is what do you get if you divide it by monthly salary by 240? What do you get? And why do we, are we dividing monthly salary by 240? Overtime rate is not daily, right? Overtime rate means hourly rate, right? If you undertake overtime work, 1.5 times of hourly rate. So then, why do we divide by 240? Yes? You have to unmute your microphone. Oh, Pavani, Kiana, please, you are trying to say something, but your microphone is muted. Why 240? No response from anybody. Hasini? Kavisa, why is it? Why it is? Why is it divided by, divided by 240?
I think so. It is divided by 240 to find the amount for 1 hour.
Yes, 1 hour, because overtime is calculated based on the hourly rate, no? So why 240? When you divided by monthly salary by 240 under the SOP and OPs Employees Act, you will get the hourly rate, right? Hourly rate. Why 240? That is my question. I repeatedly told you, under the SOP and OPs Employees Act, most of the workers are paid monthly salary. It means 30 days salary. I repeatedly told you. How many hours per day that you have to work? Normal working hours?
8 hours.
8 hours. 8 hours into 30, how many hours?
240.
That is why, right? It is divided by 240. You are supposed to, if you are getting monthly salary, your monthly salary is paid for 30 days, right? It means your weekly holiday, you are entitled to be there at home, but your salary is there. Poor day also, and the mercantile holidays also, if you want, you can stay at home, right? But your monthly, that day salary has already been there in your monthly salary. Okay, so 8 hours into 30, 240. So when you divide monthly salary by 240, you will get the hourly rate. When you pay overtime, hourly rate 1.5 times of hourly rate. So that is why, in order to calculate the overtime rate, it has to be divided by, multiplied by 1.5 times. Is it clear? Is it okay?
Yes, okay.
Right. Now you have to understand, under OPs, what do you mean by monthly salary? Sorry, let me put it monthly salary. So monthly salary, right? Monthly salary. What do you mean by monthly salary? Right. Here also, right, let me put, right, monthly wage equal, sorry, right. Now, what do you mean by monthly salary? How do you get the monthly salary? Under the SOP and OPs, in order to calculate overtime, right? Basic salary plus budgetary relief allowance, if applicable, plus cost of living allowance or similar allowance to the cost of living. This is the monthly salary, the definition of monthly salary that is taken into consideration to calculate the overtime rate or hourly rate. Under the Wages Boards Ordinance, right, overtime rate is calculated this. This is the formula. Under the Wages Boards Ordinance, I think not yeah, under the Wages Boards Ordinance, overtime rate, how do we calculate? Monthly wage divided by 200, and then when you divide the monthly wage by 200, you will get hourly rate, and in order to pay the overtime, it must be multiplied by 1.5 times. So why it is divided by 200? Under the SOPNOPs, it was divided by 240. But under the Wages Boards Ordinance, monthly salary or wage is divided by 200. Why? Can anybody think about it? Don't worry about it, whether it is correct or wrong, whether your answer is correct or wrong. Why 200? Ladies and gentlemen, under the Wages Boards Ordinance, under the Established Wages Boards, monthly salary is paid under the Established Wages Board. There are 44 wages boards, as I already explained to you. Under the Wages Boards Ordinance, Established Wages Boards Ordinance, monthly salary is paid for 25 days. Weekly holiday is unpaid holiday. That is why under the Wages Boards Ordinance, monthly salary means not for 30 days, but for 25 days. Okay. So 25 into 8, how many hours? 200. Is it clear? Asini, is it clear? I'm not asking just only one few people, just only one or two, right? When I raise questions, only one Kavisa and someone else, some other participant just answering, but I can't ask repeatedly. It is up to you. You are studying for the professional job, professional one. So when you go for an interview, or when you are performing the the managerial job in the field of HR, you have to deal with people, you have to talk with people, you have to engage, you have to exchange your views. If you are not exchanging your views, even at the class, or the lecture, the same scenario will be there when you go to work as well. Sorry to say. Okay, right. Under the Wages Boards Ordinance, under the Established Wages Boards, workers are paid for, monthly salary is paid for 25 days. Weekly holiday normally, is 4 days, but it may go up to 5 days. So it is at 25 days salary. Sometimes, some trades, it's a 26-day salary. Okay, forget about, but in general, it's a 26-day salary, but the Act defines it as 25-day salary, and not Act, the most of the wages boards. So that is why 25 into 8 hours, 200. That is why the monthly wage is divided by 200. Then you will get the hourly rate, and to pay overtime, you have to multiply it by 1.5 times and the number of hours of overtime hours worked. Here, monthly wage means basic wage plus only budgetary relief allowance if applicable. Cost of living will not be taken into consideration under the Wages Boards Ordinance. But under the Open Office Employees Act, right, cost of living also is taken into consideration, but not here. These are very, very important. Okay. I'm now giving you a question, right? Calculation, right? Question. Right. Someone is, take note, right? This is a question. Someone is someone is working right in the office of the ABC company, in the office of the ABC company, ABC company as clerical worker, as clerical worker. His monthly salary is, his monthly basic salary, his monthly basic salary is, his monthly basic salary is 42,000, 42,000. 42,000, full stop. In addition, he is paid he is paid 5,000 rupees as, sorry, 3,000, 5,000 rupees as 5,000 rupees as cost of living allowance and another 8,000 rupees as transport allowance as per the end of March 2022. As per the end of March 2022. In the month of March, he has worked 20 hours of overtime. 20 hours of overtime. Right? Full stop. Using the above information, calculate his overtime earnings. Calculate his total overtime earnings. Right. Now, 9:17, right? You have time up to 9:35. It doesn't take that much time, then you can take a break, right? So I will be taking a break and you can also take the break up to 9:35. Now almost 9:20, 9:35. The 15 minutes is more than enough for your break and to calculate this the overtime earnings. Right? Everybody has to do it, because if you do not right now, definitely there is a question for the examination. Calculations are there, right? When you paste to the examination, there are calculations, overtime calculations, EPF calculations, gratuity calculations, termination calculations, right? Yeah, there are 4-5 calculations. Sometimes, maximum, 3 calculations, big questions. So you have to study this. Okay. Do it and take a break up to 9:35. Okay, right. I think, we don't need to waste time, right? Shall we start? Did you finish? What is the answer? What is the answer? Hasini? Diniti? Nimesha? Nobody. Remember that I repeatedly told you this subject is not, you cannot consider this subject as other subject. When you study human resource planning, development, right? Hola, the textbook theories. Industrial law is law passed by the parliament. There are some ambiguities in law, gray areas. Those gray areas are cleared by the court decisions. I'm teaching you not only the labor law, the provisions of the industrial laws stipulated in labor laws, but also when I'm explaining, I consider the court decisions given by the superior courts as well, Court of Appeal and the Supreme Court. So that is the difference between this subject and the other subject. This is so complicated, right? If you do not understand very carefully, and if you do not raise questions, if you have any kind of clarifications, you can't understand this subject. So therefore, please raise questions and ask why, how, what, all these questions you have to raise. Okay, let me ask the frequent answer. Always Kavita, Avisha, what is the answer?
I think so. That is 3,500.
Okay, right. Let us check. What is his basic salary? What is the basic salary?
42,000.
42,000. And now if you look at the slide number 39, we have to calculate the hourly rate, normal hourly rate. So monthly salary divided by 240. Monthly salary means basic salary plus budgetary relief allowance if applicable. There is no budgetary relief, there is no information with regard to budgetary relief allowance of workers act allowances, but cost of living is there. How much? Cost of living? I don't remember because, I just, something came to my mind and I just explained. I don't have any written document, right? What is the cost of living? 5,000?
Yes, sir, 5,000.
Now, what is now the monthly salary that should be taken into consideration to calculate the hourly rate? 42,000 plus 5,000. How much? 47,000. That is the monthly salary. When you divide monthly salary 47,000 by 240, what is the amount you get? $47,000 divided by 240. You will get 195.8 approximately, right? 8333, right? So round figure 195 and 80 cents or 83 cents, say 80 cents. Now, in order to calculate, this is the normally hourly rate, normally, the hourly rate. So to pay overtime, 1.5 time, you have to multiply this amount by 1.5 time, 1.5 time. Then you will get 297.93.75. This is the overtime rate per hour, per an hour. 293 rupees and 75 cents. This is the overtime rate payable per an hour. How many hours he has worked? How many
20
hours? How many hours? 20
20
hours.
hours.
Now, what is the answer? 5,875. So check where you have made mistakes. Check where you said 3,000 something like that. So then check where you have made mistakes. What is the formula? First, you have to calculate normal hourly rate. Normal hourly rate is calculated salary divided by 240 under the SOP and OPS Employees Act. That is normal, rate per an hour. When you pay, the employer pay overtime 1.5 times of hourly rate. It has to be paid 1.5 times of hourly rate. Hourly rate is calculated, monthly salary means basic salary plus cost of living allowance, 47,000. So 47,000 divided by 240, you will get 195 rupees and 83 cents. When this is the hourly rate. For overtime, 1.5 times of hourly rate. Then you have to multiply this one by 1.5 times. You will get 923 rupees and 75 cents to be paid per an hour of overtime work. So how many hours he has worked? 20 hours. So 293.75 into multiplied by 20, you will get 5,875 rupees. Is it clear now?
Yes, sir, clear.
Right. So there definitely there is calculation. There are calculations. Okay. When it comes to wages boards, monthly wage means basic wage plus budgetary relief allowance if applicable, not cost of living. Cost of living will not be taken into consideration when overtime rate is paid, overtime rate is calculated. Okay, right. Next one. You don't need to, take notes in this regard. General practices for leave, sick leave. Generally, there is no kind of a sick leave, but generally 1 to 2 days absent does not require medical certificate in practice in the private sector. Absent of more than 2 days should be covered by a medical certificate from recognized medical practitioner, whether treatment is Ayurvedic or Western. The employer must be informed by telephone on the same day, generally before 10 a.m. of the working day on which employee is absent on illness. When it comes to government sector, before 12 o'clock. But in the private sector, before 10 o'clock, you have to inform. The sick leave application form, there is no such sick leave, but you can get it. Some employers are allowing. Within the limit, under the open office, you know that you have only 14 days annual leave and 7 days of casual leave. Under the wages board's ordinance, you have only 14 days annual leave, no casual leave. 4 days, mercantile holidays, yes, you are entitled, right? You are entitled for that one. But if there is no particular wages board established to cover the set of workers, the relevant workers, then they are not enjoying even 14 annual days. They are not enjoying the weekly holidays. They just enjoy only 4 days. Only 4 days. But if such workers, the workers coming under the wages board's ordinance, but wages board has not been established to cover that workers, because under the wages board's ordinance, ladies and gentlemen, annual leave, casual or whatever it is, medical, right, all these overtime rate, everything is determined by the wages board participants of the wages boards, members of the wages boards. They have the sole authority. If there is no wages boards, means, right, no terms and condition can be established. Okay, but in practice, if such workers are covered by the collective agreements, yes, right, they may enjoy certain benefits. But in practice, even though there is no particular wages boards, employers grant weekly holiday. They grant weekly holiday. Most of the employers grant 14 annual holidays. There are some wages boards, right? The workers, the certain wages boards cover the workers covered by the certain wages board. There are such workers are enjoying, more than 14 days. They are enjoying 21 days of leave. 21 days. It may vary from, but minimum is 14 days. 14 days. It may vary from wages boards to wages boards. Okay. And casual leave, right? Casual leave, the workers covered by the Sopan Office Employees Act, they are entitled for casual leave, but not workers covered by the wages board's ordinance. Prior approval should be obtained where possible, right? Example, weddings, other appointment, right? Some employers do not approve casual leave immediately after holidays, weekends, or annual leave, if there is a risk of abuse. Casual leave must either be applied beforehand, or if that is not possible, the employer must be informed by telephone or telegram, generally before 10 a.m. of the working day on which casual leave is required. The leave application should be, so these are general provisions. The annual leave under the Sopan Office Employees Act, And even under the Wages Board's ordinance, they are enjoying 14 annual days. Out of the 14 days of annual leave, at least 7 days of the annual leave entitlement must be availed up together. අතක් එකවර ගන්න පුළුවන් කියන එක. Another one is annual leave must be applied for and obtained as mutually convenient in the private sector. Mutually convenient. The employer cannot demand, the employee cannot demand annual leave at a time when it is convenient to the, when it is, inconvenient or not convenient to the employer. Nor can the employee be compelled to take annual leave when he does not wish to do so. So it's a mutual understanding, on the basis of mutual understanding. An employer may roster leave at the beginning of the year. They roster it. And annual leave must be obtained within year in which it falls due. This is very important. There is no provision to carry forward or accumulate annual leave. Right? Accumulate. You can't accumulate. And it is not possible to encash annual leave. But if worker and employer has some understanding, if both of them are, in agreement, so if you have, remaining, the annual leave, so if employer wishes to encash it, there is no harm. But, right, forcefully, right, keeping you annual leave without taking it, you can't ask the employer to pay for that one. No, it is not possible. And you can't carry forward the remaining annual leave for the following year as well. But, however, it is illegal to make payment in lieu of annual leave or to buy back annual leave, except on resignation. This restriction does not apply to casual, sick, or medical leave. So if you are retiring or if your employment is terminated, then you can, right, you can obtain what you call, you can, if your employer wishes to do so, you can encash the remaining leave. There is an exception when you retire or resignation. Resignation or retire or termination, right? Then, right, if you have some annual leave to be used within this year, and by working this year, you might have earned some leave to be used in the following year. So you can obtain all these leaves if you are resigning or if your employment is terminated. Okay. Right. Next, if the employee falls ill during annual leave, if adequate and acceptable proof is submitted, the employee is entitled to claim additional days as annual leave, provided that he has entitled sick leave. I mean, you can't obtain more than maximum 14 days and as 7 casual leaves. If you have annual or casual leave, suddenly if you fall ill, so you can obtain, but within the entitlement. Right. Now, there is no entitled. This is very, very important, right? Subtopic, entitlement of annual leave. Entitlement of annual leave. Subtopic, entitlement of annual leave. Entitlement of annual leave. First bullet, bullet 4. First bullet 4. There is no entitlement. There is no entitlement to annual leave. There is no entitlement to annual leave in the year of recruitment. In the year of recruitment. Say, for example, you enter into work with a company in year 20, say March 2022. So until first year means, year of recruitment means not 12 months, right? So if you have been recruited within this year, up to 31st of December this year, you don't have annual leave. You are not entitled within the calendar year, within the calendar year of recruitment, right? So, second bullet, in the next year, next bullet, in the next year, number 1, if recruited between 1st January and 31st March, put a dash, 14 days. You are entitled for 14 days. What does it mean? Say, for example, you enter into an employment with a company, say 1st of February 2022. 1st of February. So until 31st of December 2022, you are not entitled for annual leave, but you can earn casual leave. Right? By working 2 days, you can earn 1 day casual leave, up to maximum 7. However, if you have entered into employment on 1st of February 2022, it means that your recruitment has been taken place between 1st January and after 1st January, but before 31st of March 2022. So then, by working throughout this year up to December, you will earn 14 annual days to be used in the year 2023. Okay. Number 2, if recruited between 1st April and 30th June, put a dash, 10 days. Okay, for example, you enter into an employment, into a contract, or you will be recruited for a company on say 5th of April 2022. It means that your employee recruitment has been taken place just after 1st of April, but before 30th of June, during this period. So, while working throughout this year until 31st of December, you will earn 10 days of annual leave to be used in year 2023. Okay. Number 3. if recruited between 1st July and 30th September, put a dash, 7 days. 7 days to be used in the following year, right? 2023. Number 4. If recruited between 1st October and 31st of December, put a dash, 4 days. What does it mean? Say, for example, you will be recruited to a company for a post on 31st of 2021. You have already been recruited, but it has taken place on 31st of December 2021. Even though you have, right, just have been recruited the last day of the year, you will have 4 days of annual leave for year 2022. If you will be recruited 31st of December 2022, May Aurudde, 2020, year 2023, you will be having 4 days of annual leave, even though you know the last day, right? So, if you have any question or clarification, please raise. Next bullet form. Next bullet form. Next bullet form. Upon resignation or termination of employment. Termination of employment by the employer with notice, with notice, the worker or employee or worker, the worker is entitled to utilize the annual leave earned for that year within bracket less annual leave availed of, close the bracket. And the annual leave earned through service in the current year or that year, current year, right, calculated as follows. Number one. One day for every one day for every completed month of service in that year if total is less than 10 months. If total is less than 10 months. Number two. Number two, if the total service in that year, is more than 10 months, comma, 14 days annual leave. Right. Example, right? Mr. Saman, right? The computer operator in a bank, or say in a bank, is office, no? Right. Computer operator in a bank, right, has been recruited no, has been erase it. Has been recruited. We don't need to put has been recruited. Mr. Saman, computer operator in a bank, right? Will resign with effect from 30th of September 2022. 2022. Okay. Working in year 2021. Working in year 2021. He has earned 14. He has earned 14 days of annual leave. Days of annual leave for year 2022. For year 2022, of which of which he has utilized only 6 days. Only 6 days. Next para. Accordingly, right, if he will not use remaining remaining 8 annual days of leave sorry, he has, if, can somebody tell me what is the last sentence? Accordingly,
if he will not use remaining 8 annual days of leave.
annual days of 8 annual days of leave, right? He can obtain all that 8 leave before his retirement. Before his retirement. Before his retirement. Before his, why? After 30th of September, he is not there to utilize. I mean, October, November, December, he is not there. Right. So then before end of the year, he has already earned. So therefore, he is entitled to obtain that 8 leave. Apart from that, he is entitled to obtain another 9 days of leave, annual leave, another 9 days of annual leave. Another 9 days of annual leave before his retirement or resignation, before his resignation or retirement, as he will be working up to 30th of September and will earn nine days of annual leave. 9 months, no, September, January, February, March, April, May, June, July, August, September, means 9 months. 9 days of annual leave to be utilized in year 2023. He has, this year he has worked 9 months. So then he is up to 10 months, 1 day for 1 month service. So this 9 days leave, he can't obtain this year, but to be utilized in the next year. But as he is resigning, as he has already earned this leave, he should be allowed to obtain all these altogether 8 plus 9 altogether, remaining 8 and 9, 17 days altogether. Is it clear? Any question or clarification? This is another important area where you have to remember, because we are learning terms and conditions of employment. This is very important. As far as the terms and conditions of employment is concerned, there are two main acts. One is Shops and Office Employees Act. The other one is Wages Board's Ordinance. These are two are very, very important. Okay. Okay, I assume that you all have, the understood. Okay. Next, on resignation, the employer may request but cannot insist that the employee work during the period of notice and may make payment in lieu of annual leave. The employer may request, but the employer may ask you, okay, you have remaining annual leave, so why don't you work during, this, why don't you, but cannot insist that the employee work during the period of notice, right? And may make payment in lieu of annual leave. This annual leave are paid holidays. So therefore, if there is, employer may request the worker, okay, don't take leave, you work continuously, I will pay, right? Or, the incasual leave. If worker agrees, okay, no harm. But technically, it is prohibited. But if both can agree, employer and worker, there's no problem. The employer can insist that. The employer can insist that the employee take all annual leave due to him if the notice given upon resignation is sufficient. If you have given resignation well in advance, then the employer may ask you to take leave, all leave. If the employer refuses to avail himself, if the employee refuses to avail himself of annual leave, or if notice is insufficient, the employer cannot be compelled to make payment in lieu of such. So it is like this, right? You give, resignation at the last moment. So there is no sufficient time for the employer to grant you the remaining annual leave. So then, without giving, the prior notice, employee may ask employer, no, I have remaining, the holidays, so you have to encash it. But employer is not bound because you have not given sufficient notice. The notice period. If terminated by the employer, then if notice is insufficient, the employer is required to make payment in lieu for any utilized and leave. If employer is terminating you suddenly, then he has to encash, okay, the remaining leave. Other types of pay, other types of leave with pay. Voting elections. If you have to attend to voting election according to the Election Act, right, you are entitled, right, with pay. And jury duty. If an employee select to service as a juror at a judicial inquiry, so then for that also employer has to give, the leave. To give evidence at a judicial inquiry upon receipt of summons, leave may be granted if the dispute is one which involves the employer. The trade union work. In terms of the provisions of the trade union ordinance or collective agreement, but there is no, in the trade union ordinance, there is no provision to grant leave for trade union activities. No, right? You will learn it later. But there may be some, the provisions in the collective agreement. Collective agreements means both parties has agreed. Otherwise, no. Study leave, as maybe unpaid leave, as appropriate. And then moving to another act, Employment of Women, Young Persons and Children Act number 47 of 1956, which contains some of the terms and conditions of employment. Right? Employment of Women, Young Persons and Children, Act number 47 of 1956. Okay. Take notes, right? Another topic, Employment of Women, Young Persons and Children Act. Number, Employment of Women, Young Persons and Children Act. Number 47 of 1956. You don't need to just, you have to take, the very small note. The structure, part 1, night work in industrial undertakings, employment in industrial undertaking, employment other than, right? This is the structure of the presentation. So title, this act may be cited as the employment. So these are, night work in industrial undertaking, part 1. Subject to the provision of this part, no person shall employed at any time during the night a person under the age of 18 years. Age of 18 years. Until you reach 18 years, no night work is prohibited. Right? First bullet. No night work. No night work. No night work. If the person is under the age of, if the person is under the age of 18 years. If the person is under the age of 18 years. So there are very, specific provisions. You don't need to write everything. I will let you know what you have to, yes, right. So, ladies and gentlemen, so what do you mean by night? Night means with reference to the employment of women, night means at least 11 consecutive hours, including the period between 10 p.m. and 5 a.m. 10 p.m. and 5 a.m. Right? 10 p.m. and 5 a.m. in industrial undertakings. Okay? I mean, 10 p.m. rather high in passe, pandra paha consecutive hours. It doesn't mean that an employer can employ 11 hours. Can employ a female for 11 hours, only 8 hours, but including this period. Number B. Yes. Night means, remember that this is in relation to industrial undertaking, right? Karmika vyapara, right? Night means with reference to, right? Here, look, the first one, sorry, interpretations, sorry, industrial undertaking. Yeah, just 1 minute. The night work is prohibited for persons under the age of 18 years in industrial undertaking. In industrial undertaking. Okay. Interpretation. Night means with reference to the employment of women means at least 11 consecutive hours, including the period between 10 p.m. and 5 a.m. And with reference to the employment of persons under the age of 18 years. 18 years, between 18 and 16, yes, they can work, but not nobody who is, a person who is under the age of under the age of 16, they are not supposed to work. Means at least 12 consecutive hours, which shall end not later than 6 a.m. And persons under 18 years, 8 consecutive hours between 10 p.m. and 6 a.m. Persons attain the age of 16 years, 7 consecutive hours falling between 10 p.m. and 6 a.m. These are, you don't need to remember, right? So industrial undertaking. With respect to the women, employment of women on night work includes particularly undertakings engaged in working mines or quarries or in other works of extraction of mineral from the earth. Undertaking in which articles are manufactured, altered, cleaned, repaired, ornamented, piston, and undertaking engaged in shipbuilding, right? The generator transformation, transmission of electricity, undertakings engaged in building and civil engineering. Okay. With respect to the employment of persons under the age of 18 years on night work includes, right, particularly, right, I mean, with respect to the employment of persons under the age of night work includes particularly, I mean, previously we told that, if you have not attained 18 years of age, you cannot engage in night work. What is important is, so this is interpretation. Child means persons who is under the age of 18 years. Women means female who employs, who has attained the age of 18 years. Young persons means persons between 16 years and 18 years. This is what you have to write. Take note. Employment, the subtopic. Employment of women at night. Employment of women at night in any industrial undertakings. Any industrial undertaking. Right. The women employed, subtopic, employment of women at night in industrial undertakings. Women employed in industrial undertakings shall be permitted to work through the night within bracket, right, within bracket, 1 minute, within bracket, between 10 p.m. and 10 p.m. and 5 a.m. Between 10 p.m. and 5 p.m. Close the bracket. What I said? Women employed in industrial undertakings, right? Industrial undertakings shall be permitted to work through the night within bracket 10 p.m. to 5 a.m. including 10 p.m. Including 10 p.m. to 5 p.m. Sorry, between 10 p.m. What I said, within bracket between 10 p.m. and 5 a.m. Right. close the bracket, right? Subject to the following conditions. Subject to the following conditions. Subject to the following conditions. Number one, oh, A, B, C, D. You can put A, B, C, D. Number one. No women shall be compelled to work no women shall be compelled to work at night against her will, within bracket, consent of the female worker, within bracket, consent of the female worker. There should be a consent. Right. Number two, written sanction, within bracket, approval, written sanction. Within bracket, approval of the Commissioner of Labor should be obtained, sorry, prior written sanction, prior written sanction. Oh, approval, prior approval. Right. Number three, no women who has been employed during the hours of 6 a.m. and 6 a.m. and 6 p.m. No woman who has been employed during the hours of 6 a.m. and 6 p.m., comma, shall be employed after 10 p.m. on any day. Next, D, or number 4. Number 4. Every woman who works at night, within bracket only 8 hours, within bracket only 8 hours. Close the bracket. Who works at night shall be in receipt of a payment, receipt of a payment of not less than 1.5 times 1.5 times of the normal day payment. Number 5. right? There shall be female wardens. There shall be female wardens. Appointed to see. Appointed to see. SEEC. The welfare of women workers. Welfare of women workers. Welfare of women workers who work at night. Who work at night. Next, number 6. Right. Every women worker working at night, every women worker working at night shall be provided with restrooms and refreshments, with restrooms and refreshments by the employer. Last but not least, no women shall be employed for more than 10 days or night work during any 1 month. Next para. However, the above provisions shall not apply. Number 1, shall not apply to TO2. Number 1, women holding responsible positions of managerial or technical character. Number 2, women employed in health and welfare services. Welfare services who are not ordinarily who are not ordinarily engaged in manual work, and number 3, an industrial undertaking in which members of the same family are employed. Family means Nandamma, Bapa, Punjamma, neme, mother, father, and children, sons and daughters, right? Right. Next subtopic, hazardous occupations. Hazardous occupations. Right. Hazardous occupations has been gazetted. Hazardous occupations has been gazetted under this act, by the Minister of Labor, by way of regulations, full stop. No person under the age of 18 years shall be employed in any hazardous occupation In this regard, fine, F-I-N-E, fine, not exceeding 10,000 rupees or 12 months imprisonment, or both can be imposed by the magistrate. Okay, ladies and gentlemen, now, right, it is time to stop. We have another around 15 minutes, but so we have now so far discussed. This is batch number, yeah, today 27, English medium 11, 12, right? Slide this slide number 58, because you know we are going to discuss some other act. right? Separate maternity benefits ordinance. We have to do some calculations as well. So that is why, right, it is high time for us to stop, because, everybody is leaving now. Only 4 participants. So therefore, right, I'm not asking any questions. I will stop at this moment, and good night for everyone.
Good night, sir.
Good night. Is it okay, Kavisa? Did you understand?
Yes, sir, understood.
Right. Okay.
Thank you, sir.
Right.